appeals. And the 3 points where he has allowed the appeals are, he has emphasized on the Bijoy manual judgment of the Supreme Court, and further he has left this issue to the lady. He has left it on his choice. Lady's choice, Justice Gulia has emphasized that the choice has been left to the lady. Whatever she wants to wear, she can wear. And the third thing which he has emphasized in this judgment is that he has emphasized on the education of the girl child. He has said how the girls in the villages and how the girls in the remote areas they work. They have to assist their families. Then ultimately they go to the school. So it's very important for the girl child to have her education. So he has emphasized on the education of the thing which he has emphasized in this judgment is that he has emphasized on the education of the girl child. He has said how the girls in the villages and how the girls in the remote areas they work. They have to assist their families. Then ultimately they go to the school. So it's very important for the girl child to have her education. So he has emphasized on the education of the girl. He has emphasized on her choice, and he has depended on the Bijoy manual judgment, which has upheld this practice where a lady can put whatever covering. I appeared. One of the petitioner was Charanjit Kaur, in which she was a Sikh lady. She was saying that when I have this choice, then other girls and other ladies and other ladies from the various communities, they should have all this choice also to cover their heads while they are going to schools or wherever or which place they are going to. So, my name is Aftab Ali Khan.
Thank you very much.
Thank you.
Will the matter go to CJI or the bigger bench?
This ultimately has been referred to the CJI for constitution of the larger bench.
Larger bench.
आज का जजमेंट आज का जो जजमेंट था हिजाब का, बहुत दिन से जिसके ऊपर इंतजार था, वो आज जज ने कोर्ट ने प्रोनाउंस कर दिया है और इसके अंदर स्प्लिट जजमेंट आया है. इसमें ऑनरेबल जस्टिस हेमंत गुप्ता साहब ने उसको जो है अपील को जो है उन्होंने डिसमिस करा है और जीओ वगैरह जो थे कर्नाटका गवर्नमेंट के उसको अपहेल्ड करा है. लेकिन जस्टिस गुलिया ऑनरेबल जस्टिस गुलिया ने डिफरेंट व्यू लिया है इसके अंदर, इस मैटर के अंदर, और उन्होंने इस मैटर के अंदर उसको अपील्स को अलाउ करा है और उन्होंने 3 पॉइंट्स के ऊपर इसको मेन एम्फेसिस दिया है. उन्होंने एक तो बिजॉय मैनुअल का जो जजमेंट है सुप्रीम कोर्ट का उस पर रेफर करा है, और उसके बाद उन्होंने ये जो चॉइस है जो अपना सिर के ऊपर किसी को हिजाब रखना है या किसी को कवर करना है, ये लेडी का अपना चॉइस है, तो इस पॉइंट के ऊपर भी उन्होंने एम्फेसिस दिया है. और तीसरा पॉइंट जो इम्पोर्टेंट उन्होंने बोला है कि जो बच्चों की तालीम और एजुकेशन का मामला है वो बड़ा इंपॉर्टेंट है, और बच्चों की तालीम के लिए हमें ऐसा कोई काम या ऐसी कोई चीज जिसमें उनकी एजुकेशन के ऊपर रुकावट आए तो उस चीज का उन्होंने एम्फेसिस दिया है कि ऐसा कोई काम जो है उसके खिलाफ है, बच्चे की एजुकेशन के खिलाफ है. कोर्ट ने इस मैटर को अब आगे के लिए रेफर कर दिया है. वो उसके अंदर अब लार्जर बेंच के लिए रेफर करने के लिए उन्होंने आगे भेज दिया है इसको, बिकॉज ये एक स्प्लिट जजमेंट है तो आगे ये डिफरेंट बेंच अब आगे इसको सुनेगी.
सर एक बार अपना नाम भी बोल दीजिए.
मेरा नाम आफ्ताब अली खान.
All right, as Aftab Alam, lawyer, now speaks about what's happened inside the courtroom. He says there's a possibility that the case will now go to a larger bench. We're still waiting for the Chief Justice. Ijaz Maqbool on our screens. Let's hear him.
Girl child faces a lot of problems while they are being sent to the schools and colleges, and their right to education is more important than wearing or not wearing a hijab.
Sir, but this also means that now it will go to a larger bench. Will it go to a 3-judge bench, or is it going
No,
to be
now
a
the
9-judge
operative part of the order says that it has to be placed before the Honorable Chief Justice of India, and he is going to form a new bench. Either it will be a larger bench or it could be even 3 judges bench.
सर जो कर्नाटक हाई कोर्ट का फैसला था वो लागू अभी रहेगा वैसे ही?
नहीं, अभी तो there is a divergent view between the 2 honorable judges, and therefore until the matter is referred to a larger bench or it is taken up by another bench, that would
जो स्टेटस था कर्नाटक हाई कोर्ट में वही अभी एक तरीके से वही है, क्योंकि हो ही नहीं पाया कुछ.
there is a divergent views expressed by the 2 honorable judges, and therefore the matter has to be sent to a larger bench or to another bench.
बिल्कुल जो वकील है
All right, viewers, as we stay with our lawyers who continue joining us from the Supreme Court of India, I want to tell our viewers that as the split verdict has come out, Justice Gupta has stated in this case that he wants this case and the government order to be upheld. However, Justice Dhulia says for certain reasons he wants the government order to be quashed, as well as the Karnataka High Court. I want to once again replay the reactions coming in from the Supreme Court lawns. We've just heard right now Ijaz Maqbool speaking, who has now stated, who as the petitioner's lawyer has given out concisely what has happened. I'd like our reporters to get Ijaz Maqbool separately also to be understanding what he stated. Aftab Alam also spoke out. The petitioners have now stated that they are going to be looking at what the Chief Justice orders. So what are the options now in this case?
सरकार सेक्शन 131 के तरह यह रेगुलेट या डेलीगेट करके हिजाब पर बैन का ऑर्डर पारित कर सकती थी, नहीं कर सकती थी। ये हिजाब एसेंशियल प्रैक्टिस का पार्ट है, नहीं है। और जो आर्टिकल 25, 19, 14 सबका हवाला देते हुए उन्होंने 11 क्वेश्चन फॉर्मुलेट किए हैं और उन सारे क्वेश्चंस का जो आंसर उन्होंने दिया है यह कहते हुए कि इस आधार पर एसएलपी स्वीकार योग्य नहीं है और उन्होंने खारिज किया है। जबकि जस्टिस धुलिया ने आर्टिकल 25 और 19(1) के आधार पे ही सारे एसएलपी को अलाउ किया है।
बिल्कुल बहुत साफ।
Viewers, one by one, we can see several advocates walking into the Supreme Court as the breaking news comes in from the top court of the country. There's a split verdict. Justice Gupta says the government order was correct. However, Justice Dhulia has quashed it. Setting it aside, let me also go across now to lawyers who spoke. There's Ijaz Maqbool who'd spoken out right now, stating the options ahead, and as well as others. I'm trying to go across to also our lawyers. All right, Sambhav is going to be getting Ijaz Maqbool. If we can go back to the Supreme Court lawns, see what's happening there and get a sense of what the lawyers are going to say, because it's a split verdict from the top court of the country. This is not going to be seen as a conclusion. Therefore, the Chief Justice will now make a choice whether this case goes to another 2-judge bench or whether it goes to a 3-judge or a constitutional.
2 honorable judges. Justice Hemant Gupta has made certain issues. He has framed 12 or 13 issues, and he has held that the order passed by the GO of the government of Karnataka and the order passed by the Honorable High Court was correct. Justice Dhulia respectfully differs with his opinion, and he has based his judgment on the ground that a girl child faces a lot of problems while going to schools and colleges. She does the chores of her house and before she joins the college and school, and therefore the court has held, and he has allowed all the petitions, set aside the GO passed by the government of Karnataka and set aside the order passed by the Honorable High Court of Karnataka.
Now the question is, Justice Gupta said, let the matter go to the CJI.
No, the operative part of the order, which is of both the honorable judges, it has gone. The matter will be placed before the Honorable Chief Justice of India for a new bench to be formed. It may be 3 honorable judges, or it could be a bench of 5 honorable judges. Though we had contended before this division bench that this is a matter which requires consideration by a constitution bench, because it raises an important question of constitutional law for the first time, and it has to be examined by a bench of 5 honorable judges under Article 145(3) of the Constitution.
Will the ban remain as it is
Yes.
in Karnataka, or what implications and other things will be right now?
No, the order of the High Court would still remain till the matter is taken up by a larger bench, and unless there's a stay granted by a larger bench or a new bench, that remain in Karnataka would continue.
So when Justice Dhulia meant धार्मिक अनिवार्यता पर नहीं जाना चाहिए था हाई कोर्ट को, what does it actually mean?
What he meant was that the question whether hijab is an essential part of the religion of Muslims, religious practice or not, that question was not necessary, because here it was a question of not allowing children, the students in schools and colleges wearing hijab, and they face so much of difficulty. So that issue of going into the essential practice was not required at all. That the circular should have been tested on the ground that it violates the fundamental rights of those children who are going to the school, and that was good enough to set aside the circular.
Now, my last question is going to be, the protests are going on. Protests are going on in Iran. On the other hand, we are pleading for hijab at the apex court. How do you see this? I mean, is it so important? The hijab is so important important that
You see, let's not talk about other countries, and let's not get into this today. Let us only concentrate on what is. See, ours is a secular constitution. Our constitution permits everybody to do what there's a right to freedom of expression under Article 19(1)(a), and there's a right to life under 21. The fundamental rights are more important than these of yours that Iran mein aisa ho raha hai aur wahan aisa ho raha hai. They are in fact not secular countries. They have their own problems. But our country is governed by a constitution where this right is given to every citizen of this country.